Ladies and gentlemen, it is my honor to present here in my mother school. This is my mother college. I graduated from HKSYU College many years ago when it was just a tiny college. But now, you know, when I come back, I noticed that it became a full-fledged university, such a great building today, and you know, we have lovely students, excellent professors, and also good facilities. So I really hope that, you know, as a kind of alumni, I'm proud of the college, I'm proud of the university, and I would like to you know, send my best wishes to my mother school, my mother college, and wish this university all the best. Today, my topic is about restorative justice in Chinese communities. My focus will be in mainland China and Taiwan because Hong Kong has not yet incorporated RJ into our CJ system yet. But we can discuss this after I present my topic, my paper. So let me first of all explain what is RJ, what is restorative justice. RJ is a way of addressing conflict that focuses on repairing harm. Focuses on repairing harm. It's about harm. Someone was harmed, and we are trying to repair it. So it's about repairing harm, the so-called earned redemption. The goal is not penalize, but to rehabilitate and restore. That's why sometimes, you know, when it was introduced, for example, in New Zealand, it was used for juvenile delinquents, for children and young persons and families. And then over the years, it has been expanded to different parties, different sectors, including adults, including domestic violence, including families, and so on. The purpose for restorative justice to make victims central, because, you know, in the arbitrations, in the court systems, offender is always the central. Victims is neglected. But for RJ, we would like to bring in victims' voices. So it makes victims central, try to empower them to have a key role in the justice process. So there are a few principles of RJ. Emphasis on full participation and consensus, which means that we would like to involve victims, victims' supporters, offenders, offenders' supporters, and sometimes bystanders, community leaders, and all the stakeholders concerning about that issue, concerning about that crime. So at the end of the day, we would like to arrive consensus, but sometimes partially consensus is still okay. We can talk about it later. And the principles of restorative justice is to heal what is broken. What is broken? Perhaps if a thief came into your house and then broke your vase. Okay, a vase is broken. So how can we amend it? How can we heal it? A vase is broken, right? So it's not easy to compensate, to repair, right? But there must be harm bring into that case. So we're talking about harm repair, repairing harm, and repairing relationships, okay? Repairing relationship, repairing harm. So perhaps sometimes it involves in restitution, reparation, and compensations. So principles of RJ focus on full and direct accountability because the offender done something wrong, right? Someone did something, bad deeds, we call it bad deeds, the doers, okay, doing something bad. So we are not treating the crime leniently. we are not just deal with the crime softly. We would like the offender to take accountability. And that's why, even though we are talking about RJ, although it is not a kind of retributive justice, but we still want an offender to take accountability, to face what he has done. So take direct accountability to restore what has been divided, okay? For example, relationship divided, parties divided, opinions divided, and to strengthen the family or the community in order to prevent further harms. And that's why RJ is now linked to desistance in offending, which means that are we able to desist criminal activities, helping the offenders not to offend again. So it's a kind of tertiary crime prevention. It is certainly not primary crime prevention, but it can be seen as a secondary or tertiary crime prevention. And we really hope that to repair harm done, restore relationships. In the recent 2 decades, key processes that are now seen to be central to the RJ approach are conferencing. So this word is firstly adopted by the New Zealand people, the New Zealanders or Australian, and they adopt the so-called restorative conferencing as a kind of restorative practices. And nowadays, in New Zealand, Australia, England, Canada, Singapore, Belgium, the Netherlands, and so on, and more than 50 to 70 countries are now familiar with RJ, and they try to incorporate certain parts of RJ principles and practices into their CJ systems. In Canada, perhaps they may call it circles, the so-called peace circle, especially for those who are from the Aboriginals. And they will sit in a circle, you know, doing some ceremony before they engage into the mediation. And then they go rounds and then try to be genuine and then express their feelings and amend the harm done. For some other parts of the world, United States, Germany, Austria, England, and elsewhere, they are more familiar with VOM, Victim Offender Mediation, or VORP, Victim Offender Reconciliation Programs. So these are the terms. Today, I do not want to focus on the historical development of RJ in different parts of the world. But perhaps since we have visitors from overseas, and we do have different professionals coming from legal professionals, neuroscience, psychiatric, psychology, social work, and criminology, and so on. So really interdisciplinary. So perhaps I would like to highlight some of the recent developments of RJ in mainland China and Taiwan, a part of the Greater China region, so that you may be more knowledgeable about the recent development of RJ. RJ in mainland China. These are indeed the books written in Chinese, and they have already published 10 years ago, so widely spread around, and then, you know, it's about RJ. So perhaps for some of you, you may not be aware that RJ has already been well known. The terminology has already been well known in mainland China. I will tell you more about this because I have conducted kind of content analysis on Chinese academic journals to understand whether RJ are really growing rapidly in mainland China. I conducted a comprehensive literature review. the review search all the printed academic journals written in Chinese with the keywords of 恢复性司法, restorative justice, and 调解, mediation. These two words. I include these two Chinese characters for keyword search in the China Academic Journals full text database. So this presentation is about 4 years content analysis. 4 years content analysis. Indeed, I have already collected the journals of the 2015, and it's yet to be analyzed. But for 4 years, you can see there were already 588 pieces of journals, pieces of articles. I read most of them because, some of the journals are rather brief. Even though it's already included in this full text database, but some journals just have 2 pages. Some articles just have 2 pages, and some are as long as 7 to 10 pages. So as a Chinese, it's not difficult for me to read them through. So I read most of them. Together with my research assistants, we classify them into different categories. So out of the 588, there are 5 major themes. Theme 1, RJ and victimology, 50 pieces of journals, so 8.5%. The most popular topics are talking about RJ and criminal justice, because criminal justice is so broad. But I deliberately excluding juvenile justice because my focus is on juvenile justice. I also write articles on juvenile justice in RJ, so I set aside JJ from the CJ, all right? So you can see, without JJ, there are already 391 journals, articles. So for film fee, 13%. And some of journals, their main themes are focused on Chinese philosophy. So talking about whether Confucianism, Taoism, and some other Chinese philosophy are matched with the RJ, and talks about, Chinese, characteristics and so on. So I would talk about more regarding this later. So the theme 5 is about development of RJ in Western countries. They cite examples, real stories from different overseas, and then documents, what had happened in different parts of the world, in UK, in Germany, in Australia, and so on. So they write in Chinese, but they cite the examples from overseas. So you can see, these are the categorizations. So table 2 is about RJBUs at different levels of CJ system. So perhaps I try my best to classify them into pre-court, during court, and post-court. But before pre-court, it's about public security, which is police. So RJBUs in policing and public security, so neighborhood level, 15%. RJBUs in prosecution level, they call it, public prosecution. So it's about pre-court, 28%. So how about during court? Yes, when the case was brought to the court, and then they can still order mediation can be conducted. So 29%. So after sentencing, they can still use RJ. For example, suspended sentencing, okay? Suspended sentencing. Or, giving them conditions while giving them sentence, all right? So, post-court level, 17%. And also in the community correction and reintegration, which is, for example, when they were already imprisoned, or youth detention center, or youth training center, and something like that, before they release or after they release, they may ask them to join in some RJ programs, and these are 12%. These are 12%. My table fee is about whether, in general, they are in favor of the development of RJ, the so-called Western RJ concepts, all right? The so-called Western RJ concepts in China. So most of them do. Strictly in favor, 75%. Moderately in favor, because they have different kinds of worries, different kinds of criticisms about this so-called the Western stuff. So, and they still want to further improve it before strictly adopting these Western models. So 24%. Not in favor, only tiny, 1.4. In my articles, I have already explained this. Perhaps during this period, at that time, the concepts of building a harmonious society proposed by the former presidents of Wu Jintao has been very popular over past 10 years. So building a harmonious society, try to be consensus, don't have so many disputes in the mainland China is the prime objective of everybody, okay? So perhaps under such a slogan, under such a direction, so scholars, lawyers, criminal justice professionals, they tend to abide to these directions. So they tend to agree that, oh, come on, the Western RJ concepts is very similar to us. So why don't we adopt it, and then we can really expand mediations in line with the president's slogan. Perhaps some of you, if you are coming from different countries, you may be interested to know more about Chinese philosophy, values. So we have further classified all these journals and see whether they have mentioned anything about Chinese values and concepts, traditional values. Not adding up to 100%, okay? Whenever they mention it, we count. Around 50% mention repairing harm done, all right? So they really focus on this, okay? They think RJ mediation can repair harm done. Around 40% mention about harmonious society and stability. This is so-called my proposition, okay? Linked to the president's slogan. Around 40% talk about offender reintegration, because most of these criminal justice personnel do have a focus on offender rehabilitation, crime prevention, and so on. So they buy in this idea. This is an interesting peace comforts. That is my translation. Perhaps if you understand Chinese, you know what I mean. Are we able to adopt peace comforts? By means of peace comforts, which means that sometimes we sacrifice individual interests at the expense of collective interests. So that is Chinese, right? That is Chinese collective. So you will see, you know, quite a number of people buy in this. This is typical Chinese. Full participation, this is emphasis by UN, this is United Nations. Whenever we talk about using RJ in criminal matters, full participation should be emphasis, but in China, not pretty much, okay? Not full participation. Perhaps the emphasis on participation of authority figure. Avoid litigation. This has been discussed and mentioned by a lot of Western scholars, saying that, oh, come on, Chinese always prefer avoiding litigation. They don't want to go into prison. They don't want to go into court. There are a lot of Chinese idioms talking about this, okay? We don't want to go to the court, all right? Something like that. But nowadays, not many people emphasize on this, okay? Perhaps on the contrary, since the law reformed in 1980s and 1970s, there are more and more court cases brought in to the different levels of courts, and people are more accustomed to court hearing. Perhaps they would like to make good use of the court hearing proceedings to earn back what they have lost. So nowadays, it's just opposite. It's just opposite, going to the other side. According to John Braithwaite or some other criminologists, they mention about forgiveness. Chinese always focus on forgiveness. But sorry, I would say not now. Not now. Especially in the mainland China. Sometimes they don't want to forgive you. All right? Perhaps they pay more emphasis on compensation or, money. So there are comments on the movement. There are comments on the rapid development or worries about rapid development of RJ in China. I will talk about this later. But shaming is another concept, not really emphasis by the nowadays contemporary Chinese. But overall, judging from the literature review, RJ or RP seem to be prevalent and increasingly used in China. Let's examine how RJ and mediation be used in China. In contemporary China, there are many different types of mediation practices, commonly known by the public, including the so-called community mediation. Sometimes we call it informal mediations. The people's mediation, administrative mediation, judicial mediation, criminal mediation, and even grand mediation. 大調解, 大調解. So today I don't have much time to cover all this. I will just focus on some. In a broader sense, all types of mediations currently practiced in China can be considered as RP practices. Let's focus on informal mediation first. Community mediation refers to general type of mediation commonly used in most of the neighborhoods. 調解, has long existed in China and is often used in dispute resolutions. I think as a Chinese, we are accustomed to 调解. Chinese scholars sometimes refer to 调解 as a type of traditional Chinese RJ. In old China, neither an elder of the village or a community leader of the clan may become the third-party mediator for resolving disputes. 和事佬, an elder resolving disputes. Under the influence of Confucian values, regulations, and mechanisms, the Chinese are believed to have shaped a mediatory society over dynasties, for many dynasties. I have written an article talking about a few dynasties that they have already introduced mediations. With the establishment of the formal legal and CJ system, community mediations practices do not fade out, and this kind of practice does occur spontaneously in many occasions. I could still remember in one occasion I was in Shanghai. There were two bicycles bumped together. Just 2 to 3 minutes times, there were more than 50 people to 100 people surrounding the incident. And people, voice out their opinions, trying to help and mediate, This is informal mediations. Everybody will see it when you travel along China, all right? Different parties, different provinces, different cities. This is not uncommon. It's still used. It's still used. I saw an article talking about the people, normal people, becoming mediator. Not a professional mediator, but the crowd. The crowd is a mediator in China, not professional. You don't have to be trained to be a mediator. This is different. People's mediation is incorporated many years ago, right after 1949. Since the establishment of the Communist China, so in 1949, they tend to abolish most of the laws. I don't know whether you are familiar with all these histories. They think that the old systems belong to the nationalists, KMT, right? So they don't buy in these so-called old systems, and they abolish all the laws, and then they create their own laws, and then they call it People's Court. Remember that? People's Court. And they also introduce mediation committees. That's why. So while the Western countries, they are talking about, oh, come on, we are the proponent of RJ. But when we dig into the histories of China, indeed, we have a long history of mediation. The provisional regulations on the organization of PMC adopted in 1954. For a common PMC, it normally consists of 3 to 9 persons. It was clearly specified, and they have a 2 inches thick of mediation manual. Since you guys are developing your own manuals in Hong Kong, in different parts of the world, please take a look of the mediation manual in China, 2 inches thick, so thick. I don't know what were inside, but many stipulations over there. Under the guidance of the People's Court and the local governments, mediators do receive some kinds of training. And the PMC has settled a wide range of cases, including divorce, inheritance, parental and child support, debts, real property productions, and minor criminal cases, and so on, okay? So there are more statistics about PMC. I have discovered that the number of mediation committees, in terms of committees, not members of mediators, committees. In terms of committees, there were around 155,000 in 1950s, already 55,000. Take a look of the figures here. In recent years, we have over 9 million of mediation committees. So you just can't imagine. It's talking about committees. Each committee have 3 to 9 mediators. So you can imagine, you know, the so-called mediators, how many in mainland China? So many. So I don't have time to dig into the criticism of every types of mediation. I have written an article regarding this. But let's go to judicial mediation first. This is 法院调解. The People's Court can conduct judicial mediation with the consent of all parties. So judicial mediation is applicable to a wide range of civil dispute cases. So including divorce, adoption, custody, inheritance, and so on. It is also applied to economic disputes and minor criminal cases. That's why RJ is also linked. Whenever it talks about criminal, okay, it's about RJ, it's about RJ. So, but certainly, most of the judicial mediation is not about RJ. The fourth one is about RJ. Closely linked to RJ, they call it criminal mediation, or sometimes they call it criminal reconciliation. Criminal reconciliation. Criminal mediation refers to the mediation practice designed for offenders who have committed criminal acts but possess a sense of remorse. This is the conditions. So in China, they still emphasize on this. Possess a sense of remorse. So if you don't possess any sense of remorse, perhaps you are not eligible into criminal mediation. So it was initially applied in cases of assault with minor injury in the period between 2002 to 2004. So criminal mediation became a widely accepted practice within the police departments and the people's prosecutions and also people's court. Different levels of CJ can apply criminal mediation practices, okay? So they can make good use of the criminal mediation practices by discretions, by using discretions, or by interpreting the law. So throughout the development of criminal mediation, the scope of cases in which criminal mediation is applied has gradually expanded to include insult, serious traffic offenses, the intentional destruction of property, robbery, theft, fraud, even rape, extortion, and murder by negligence. So it can also be applied to serious punishable crimes where a sentence of imprisonment of over 3 years applies. So they have recently amended the criminal procedure law in China in the year of 2012, 5 years ago, and it clearly specifies all this so-called criminal mediation, discretionary use of, conditional non-prosecution, and so on. So I will go back to the criticism, but let's take a look of the development of RJ in Taiwan. The development of RJ in Taiwan came to prominence in late 1990s. So in 1997, the Ministry of Justice set up a committee to review criminal policies. In 1999, a white paper on prosecution reform was published in response to growing problems of the justice sectors, such as increase in serious crimes and constraints on judicial resources in prison overloaded. That's why they started to adopt RJ. So after a few years later, they then proposed a kind of pioneer project in Taiwan. It is called RJI, Restorative Justice Initiative. This is a very important step for moving forward, 2009, 8 years ago in Taiwan, operated by the Ministry of Justice. They used 2 years to pilot the program, and then during the pilot, they select 8 district prosecutors' office in the whole Taiwan, 8 district prosecutors' office. After these 2 years, they found it good, they found it applicable, and they found it useful, and then they expanded to 14 to 15 district prosecutor's office. Why do we focus on district prosecutor's office? Because by now, they still don't have the law staying clearly that, how RJ be used. They only given the discretions to the prosecutors' offices to run their own RJ. You know what? I just went to Taiwan for a few months and then visit a few prosecutors' office. And different prosecutors' office borrow the ideas, the basic principles, and then they receive training, and then they set up their own mediation services. So different prosecutors' office may have different practice. Interestingly, and they employ different numbers of staff to be mediators. In some prosecutors' office, which means that in some district of Taiwan, they conduct mediation like this: one mediator, one trained mediator, plus one supporter. Okay? So in some prosecutors' office, they allow supporters coming from victims' organizations. So normally they will have a co-mediators, the so-called co-mediator. But in some other prosecutors' office, they emphasize on one mediator only. They think one mediator is enough. So different prosecutors' office have different models at the moment. Okay, very interesting. They are still, pioneering them. Until today, they have not yet passed any law talking about RJ. All right, but discretions. These are the figures. Over these 5 years, so you can see they have already tried run 1,200 number of cases. So some cases are dropped. So accepted cases are more than 1,086. So out of this 1,000 something, so they engage in the so-called RJ dialogue, okay, RJ dialogue. And then how many got an agreement? Around 400, which means that they think these 400 cases are successfully mediated with agreements and consensus, all right? Everything settled. So some has no agreement, but when I dig into what are these, they told us that for this cannot achieve agreement, they have already gone through the RJ dialogue, gone through all the conferencing. But eventually, they are not able to reach a consensus, and then these cases refer back to the court, okay? Go through the prosecutions again, and eventually the court make a decision, okay? So that is the 153. A great number of cases were withdrawn because of some other reasons, many other reasons. Sometimes victims do not want to come, sometimes they don't agree with the mediators' practice, sometimes they just don't have the time, sometimes they engage in 1 or 2 times and then they withdraw. Different kinds of stuff, but there were already evaluation reports regarding these so-called pioneer projects. So nowadays in Taiwan, the Taipei University has a lot of experts in RJ. One of them is a good friend of me and Yuehua, Jim Xu. Jim Xu is now a very prominent RJ scholar, the current president of the Asian Criminological Society. So they conduct a very comprehensive evaluation on the RJ initiative. Out of 463 cases, 388 were considered by the prosecutor office as matching with the criteria of mediation. 40% of the qualified cases were then selected for evaluation survey. They were invited to join in the evaluation survey, asked them to fill in the questionnaires. Eventually, 156 weather questionnaires were collected. Results indicated that psychological and tangible harms caused by the offending behaviors could be restored through mediation, positive results. So high degree of consensus, high degree of satisfactions when they go through this RJ. Certainly, they also identify some difficulties and challenges in the implementation. Some of the administrators and mediators were not skillful enough in mediation because they only received 3 days of training. Okay, 3 days of training. Most of them are psychologists. Some of them are social workers. Some of them are teachers. Some of them are prosecutors, all right? So coming from different sectors. And they were hired by the prosecutor's office. And they received some limited salary. Motivation to participate in VOM was low for most of the cases. That's why we saw a high number of withdrawal. And this may be due to the fact that mediation meetings were administered through the prosecutor's office, because prosecutor's office is so-called the authority figure, right? They are not really neutral. They are not really impartial. So there are similarities of RJ in mainland China and Taiwan. RJ are commonly found in both pre-sentencing and post-sentencing levels. At the pre-sentencing stage, prosecutors possess power to initiate RJ through deferred prosecutions. For post-sentencing stage, mediation practices are available for offenders regarding offenses and duration of sentence. So this is my worries. Peace comes first. Unlike in Western RJ, the safety and interests of victims, as well as individual rights, are regarded as top priority in the process of mediation. The Chinese method of performing RJ is different because collective interest, social solidarity, and community harmony are normally the top priority rather than victim or perpetrators' rights. So that's why I have come up with a few points of matters of concern regarding Chinese mediation practices. First, mediators might be biased and aim at getting things done according to the family rights or party line politics. Second, mediators sometimes emphasize moral teachings and collective interests than individual rights. There is a concern that the mediators will share their opinions towards the case and may persuade parties to resolve the conflict with the account of family bonds or interests of one party at the expenses of others. Now, regarding domestic violence, there are a lot of articles talking about this already. Domestic violence has become an increasingly serious problem in mainland China. In an attempt to attain settlement, mediation is seen as a kind of compulsory exercise before the court hearing. So the judge may order you to go for mediation before you go back to court. And it's sometimes compulsory. And this is not good to me, right? Why don't we enforce to conduct mediation before going to court? So there are already a lot of criticisms talking about this, and this may sacrifice the legal rights of a woman supposedly enjoying. So in China, judges sometimes share a dual identity, representing adjudicators as well as government officials. In some cases, interestingly, so they adjudicate or they mediate the case first, but they take off the cloth of the judge and then they go for mediation. But after that, the mediation was not successful, and then they wear back the cloth of the judge and then conduct the court hearing again, the same judge doing two things. So this is a big worry to us. So they also bear potential hazards when dealing with collective disputes, largely because of how they settle mediation cases is related to evaluation of their work and future promotion. In some provinces, we were told that if you are able to trial or to practice small mediation cases, you will be promoted. So there is another worry about this. So this leads to public worries about the party government's interference in managing disputes and may lead to a lack of impartiality during the mediation process, especially when the amount at stake is high or the legal issues are related to national interest, the so-called, public security, or when the outcome of the case might affect the particular government officials who might have been involved in corrupt behavior. So I don't have enough time to cover my whole presentations. I know time is up. So, but my conclusion is that no worry. So I saw a lot of good mediators. They are trying to do a good job in China. A good mediator may help to bring a good results. If you are interested, read my PowerPoint later. And then I also saw some prosecutors' comments talking about their own experiences of going through RJ, and they are genuinely involving in RJ practice as a real justice mediator, real mediator, genuine mediator, and they are not biased. I saw some of them are not biased. So that's why I can also reassure you that no worry, they are good people. Okay, they are lovely mediators. If you guys are interested to work with the Chinese, then please devote your professional knowledge and trainings and then help them out and then try to assist them to run a so-called genuine, impartial mediation so that, people's rights can be protected. My conclusion, sorry for that. So my conclusion is that I advocate for involving neutral and impartial third-party mediators. That's why So when Dr. Leung is talking about evaluative mediation, so I don't really agree with that in China in particular. You know, if you are adopting evaluative mediation, who has the power to make the evaluation? Emphasizing voluntary participation, you know, my argument is that must be voluntary, not coerced. Minimizing the influence of the Chinese moral imperative, diluting family and political party influences, and emphasizing proper procedures for screening targets and balancing the power between participating parties. These are the most important principles that if we are going to promote RJ and restorative practices for criminal matters in China or even in Hong Kong. Thank you very much. Thank you.